35 of your or the.
It says, my lord, that it was in the context of lapsing.
Page number?
Para
Para
235,
235 of the
my lord,
judgment.
12379. My lord, the learned judges, my lord, is pleased to quote Nambudri
1, 2, 3, 7.
12379 at 12379.
Paragraph 236.
236.
232 से start हो गया. Yes.
Yeah, yes, my lord. This para is quoted. It was cited, my lord. And please, my lord, bear in mind that Nambudri is a 5-judge bench.
This not. Yes, sir. Absolutely nothing to do with this matter.
So para 236 may I read, my lords.
236, read the judgment.
Lord, can I show, my lord, the facts of Nambudri first, my lord, if your lordships would like to see. My lord Justice Narasimha, my lord, 1186 is the page number, my lord, of volume 3. Volume
5.3.
5.3 at page 1186. Lord, even if the context was lapsing, what I read is the ratio.
Ratio.
5-judge bench says
That
that
wherever the assembly required timelines to be provided,
they have
they
provided,
have provided,
and therefore we cannot provide for a timeline. The prayer was this, that you provide for a timeline, otherwise it would lapse.
Was pending before the president, and if this assembly would dissolve.
Yeah, they say wherever it is. I am reading, my lord, 1186, Lord, which is Nambudri, the facts of Nambudri.
Broadly stated.
356 order in this.
Lord,
yes,
my lord, the Chief Justice says 1186, the facts of Nambudri. Just above 1186, my lord, para 2.
starts from 1185, yes.
The Kerala Agrarian Relations Bill. Your lordship gets, my lord?
Yes.
The Kerala Agrarian Relations Bill, which has ultimately become the Act, was published in the Government Gazette of Kerala on December 18, 1957, and was introduced in Kerala Legislative Assembly on December 21, 1957, by the communist government, which was then in power. The bill was discussed in the Assembly and was ultimately passed by it on June 10, 1959. It was then reserved by the Governor of the state for the assent of the President under Article 200 of the Constitution. Meanwhile, on July 31, 1959, within less than a month, more than a month, the President issued a proclamation under Article 356 and the Assembly was dissolved. In February 1960, midterm general elections took place in Kerala, and as a result, a coalition government came into power. On July 27, 1960, the President, for whose assent the bill was pending, sent it back with his message requesting the Legislative Assembly to reconsider the bill in light of the specific amendments suggested by him. On August 2, 1960, the Governor returned the bill remitted by the President with his message and the amendment suggested by him to the new Assembly for consideration. On September 26, the amendment suggested by the President was taken up for consideration by the Assembly, and ultimately on October 15, 1960, the bill as amended in light of the President's recommendation was passed by the Assembly. It then received the assent of the President on January 21, 1961, and after this thus became law. This was the facts, and the issue was whether the bill would lapse or not, my lord. Now your lordships may kindly come to para 14.
1/4.
1/4, my lord, which is at page 1193. Your lordship gets, my lord. 1193, my lord, gets, my lord. Para 14.
Yes.
In this connection, it is necessary to consider Article 200 and 201, which deal with bills reserved for the assent of the governor or the president. Article 200 provides inter alia that when a bill has been passed by the legislative assembly of a state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for consideration of the president. The proviso, my lord, it's paraphrasing the proviso, my lord.
You had already read para 15 to us.
Para 15.
Either you or the learned attorney, either of you.
No, I read just now. I just now read, my lord.
Earlier it was.
Just now I read, my lord, that court said that no, we cannot read into any timeline. My lord, why the court is seeking 197(1)(b? Please have a look at 197(1)(b). This para 15 reads 197. Restriction on power of legislative council as to bills other than money bill, where there is a time limit stipulated. This question was considered. It is a ratio, not a passing reference. This is a statement of law. Lord, it's again paraphrasing.
They should read 190.
But Lord, it refers to 197. Para 14 and 15 both refers to 197, and 197 provides for a bill, for a time limit for a bill.
Read 196.
So under 197, there are specific timelines.
Yes. And 200 does not have. So virtually the prayer was that you read some timeline in 200.
And the argument was that the bill had lapsed.
Yes.
That was rejected.
Yes. Article 196, sub-article 5. And the Supreme Court says it doesn't lapse because there is no timeline. And whenever timeline was required, it is stipulated.
That was the question.
That's right.
So it is a statement of law. It's not a passing observation of a constitution bench. Well, that is why, my lord, the constitution bench gives the dates also. Time was the issue, my lord, that whether it should have been done within particular time limit. Now, my lord, again, my lord, B.K. Pavitra, I have read, my lord, I'll not repeat that, my lords. Now, my lord, the court Lord, relies upon 3 judgments, my lord, for fixing the time limit. I'm sorry, this Kesham judgment, my lord, that is the Manipur Assembly Speaker. I don't wish to, my lord.
No, Kesham, I have already distinguished.
Lord, it was a tribunal.
Because all the constitution benches have held that Speaker, while acting under para 6, acts as a tribunal, and therefore is amenable to the jurisdiction of the High Court under Article 226, 227, and this code under 136. And while discharging those functions, it does not enjoy the constitutional immunity under 112 and 212.
Yeah, that Raja Rampal judgment 212, etc., will not apply because he is a tribunal. And therefore,
It's a tribunal, and right from Kyoto, it has been consistently held
yes,
that he doesn't enjoy the constitutional
immunity under the
under
privileges, etc.
112 is over Speaker and Chairman, and
212 for assembly.
over the state legislatures are concerned.
Yes. So it is, my lord, that can never be a justification for prescribing guideline for a constitutional functionary exercising.
Kesham also does not lay down guidelines in general.
It's only for 10th schedule.
No. It says in the facts of the case.
Yes, it doesn't find other things.
Because an argument was made
It was paid,
like the UP case. The court itself should exercise the power and declare them to be disqualified because the disqualifier was apparent.
Mayawati judgment, my lord.
Not
It
Mayawati, Rajaram.
was, my lord, Yadav, Rajendra Singh Rana.
Rajendra Singh Rana was
There, my lord, it was Mulayam Singh Yadav versus Mayawati. Court said the now
Maya-
2 months have left.
from Mayawati's party, the 13 MLAs that defected to Mulayam Singh.
Mulayam Singh
They
Yadav,
had given a letter that Mulayam Singh should be made the chief
Chief
minister.
Minister.
And-
That was
and-
treated.
And this court held that the very fact that the MLAs elected from BSP wrote a letter that
Other leaders should be.
the leader of the SP should be made a chief minister. Itself was sufficient enough to disqualify them and
On the ground that they
passed an order of disqualification directly in the Supreme
Yeah.
Court.
And they said, but the Honorable Court said in Rajendra Singh Rana that they're writing a letter requesting the President to invite the other party's leader amounts to their voluntarily giving up membership of their original political party. Now 2 months of the assembly session has left, and therefore there is no point in returning the matter to the Speaker, and therefore we decide it here and declare them disqualified. But that is again, my lord, Speaker is a tribunal. My lord, that, in my respectful submission, my lord, I may not labor much. My lord,
That has been followed in Nebam Rebia and
Nebam Rebia, yes.
and Subhash Desai.
Yes.
Well, I've been making this argument for 5 years that it's a tribunal, Mullah, then every time the resistance was, but he's a speaker. Luckily, Mullah, we have your lordship's judgment, Mullah. But for 5 years, I've been saying that.
Constitution,
I know,
which
but
benches
Mullah,
also-
for 5 years, we've been saying because speakers were not deciding issues. And
And,
for years, they were not deciding. And I was saying they are tribunals, but for 5 years, Mullah, nobody accepted that position because the other side would say he's a speaker. Then your lordships decided the matter. And we are so happy that you did, Mullah. At least that put a quieter.
we have held that we don't want to create a situation of operation successful and patient dead. Then we have said that we don't want to create a situation that operation successful and patient dead.
Lord, kindly come to page 238. Lord, interpretation of as soon as possible. Lord, your lordships have seen two things. In Article 200, main part, no time limit. Article 200 main part does not prescribe time limit. The proviso says as soon as possible. In this context, I'm just giving one judgment on as soon as possible. Please come to page 238. Lord, this was a case of preventive detention and therefore directly Article 21 was involved. Article 21 and Article 22, personal liberty, fundamental rights. Abdullah Kunhi versus Union of India. In Francis so-and-so,
Which page have you said?
Lord, I'm sorry, 238. 238.
There are 253.
Yes, my lord, at the foot, para 14. In Francis Corel Mullin versus WC so-and-so, Justice Chinnappa Reddy, while dealing with the time imperative for consideration of representation, has emphasized, we, however, hasten to add that the time imperative can never be absolute or obsessive. The court's observations are not to be so understood. There has to be leeway depending on the necessities. We refrain from using the word circumstances of the case. One may well imagine a case where a detainee does not make a representation, then it is various situations concerning detenue. I have given the situations which the governor may say. Ultimately, my lord, the bold line, but allowance must surely be made for the necessary consultation where legal intricacies and factual ramifications are involved. Lord, here in this case, political considerations, politics not, my lord, in the derogative sense of the term. There can be, my lord, a political statesmanship which is at play. There may be a good reason for him to let the situation calm down. It might be, my lord, having some impact on the national policy. He might be in consultation with the President of India. There can be several. These are all polycentric decisions. These are not A versus B, whether A is right or B is right. It has consequences, it has fallouts, it has social implications, it has economic implications, it has implications outside the state. Lord, similar is the case. Lord, in Jogle is passed again by the House or Houses as the case may be, the governor cannot thereafter withhold assent. The second proviso to Article 200 stipulates that the governor must not assent to the bill but necessarily reserve it for the consideration of the President if the bill, upon being enacted, would derogate from the powers of the High Court in a manner that endangers its position under the Constitution. Save and except for bills falling within the description contained in the second proviso, where the governor must reserve the bill for consideration of the President, a discretion is conferred upon the governor to follow one of the courses of action enunciated in substantive part of Article 200. Aside from bills which are covered by the second proviso, where the governor is obliged to reserve the bill for consideration of the President, the substantive part of Article 200 does not indicate specifically the circumstances in which the governor may reserve a bill for consideration of the President. The Constitution has entrusted this discretion to the governor. The nature and scope of the discretionary power of the governor to act independent of or contrary to aid and advice of Council of Ministers under Article 163 was discussed in Nabam Rebia versus so-and-so, where, my lord, 154 is quoted. No, I've read, I'll skip that. Then para 67 of B.K. Pavitra. The framers carefully eschewed defining the circumstances in which the governor may reserve a bill for a consideration of the President. They did not give instances, they left it open-ended. By its very nature, the conferment of power cannot be confined to specific categories. Exigencies may arise in the working of the Constitution which justify a recourse to the power of reserving a bill for the consideration of the President. They cannot be foreseen with the vision of a soothsayer. The power having been conferred upon a constitutional functionary, it is conditioned by the expectation that it would be exercised upon careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. The entrustment of a constitutional discretion to the governor is premised on the trust that the exercise of authority would be governed by constitutional statesmanship. In a federal structure, the conferment of this constitutional discretion is not intended to thwart democratic federalism. The state legislatures represent the popular will to those who elect their representatives. They are the collective embodiment of the will. The act of reserving a bill for assent of the President must be undertaken upon careful reflection, upon a doubt being entertained by the governor about the constitutional legitimacy of the bill which has been passed. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the President. Article 254(2) is an illustration of the constitutional authority of the governor to My Lord Justice Suryakanth has the same 5 minutes. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the President. Article 254(2) is an illustration of the constitutional authority of the governor to reserve a law enacted by the state legislature for consideration of the President in a specified situation where it is repugnant to an existing law or to a parliamentary legislation on a matter falling in the concurrent list. eventually, which is specified in Article 254(2), does not exhaust the ambit of the power entrusted to the governor under Article 200 to reserve a bill for consideration of the President. Apart from repugnancy in matters falling in the concurrent list between state and the parliamentary legislation, a governor may have sound constitutional reasons to reserve a bill for consideration of the President, apart from the repugnancy issue. Article 200 in its second proviso mandates that a bill which derogates from the powers of the High Court must be reserved for consideration of the President. Apart from bills which fall within the description set out in the second proviso, the governor may legitimately refer a bill for consideration of the President upon entertaining a legitimate doubt about the validity of the laws. By its very nature, it would not be possible for this court to reflect upon the situations in which the power under Article 200 can be exercised. This was noticed in the judgment of this court in Hext, so and so. Lord, I'm sorry, I'm always confused with this pronunciation. Excluding it from judicial scrutiny, the court withheld. Lord, I have read this, my lord, when I read Hext, my lord, so I'll not. Yes, my lord. I'm not reading it, my lords. Now, your lordships, my lord, kindly come to, my lord, this point is over, my lord. My lord, there are some issues, my lord, which we have divided with a view to save time, my lord. My learned friend also would assist your lordships, would supplement without, my lord, repeating, my lord. They would be able to more and effectively assist your lordships. My lord, kindly come to 204.
In a louder manner.
Yes, sir.
Both of them.
No, anything remains, no, not survives. Yes, sir.
We'll have to put off the wife.
Yeah. There was an interesting incident. I'll not share it here. My Lord Justice Narasimha, me and my colleague, my Lord, we went to Pune for arguing one matter, my Lord. Before NGT Pune, my Lord. But I'll some other day, not in the matter. Lord, question number, page 204.
Why are you unnecessarily thinking about anxiety?
No.
Either you should have not mentioned.
Now we have
Or
mentioned
if you have mentioned, you mention it fully.
Yes.
Unless it is not embarrassing to my learned brother.
No. It's not, my Lord, embarrassing to his.
So what happened in NGT Pune?
Lord, I'll just say with his permission.
Not like to proceed out.
No, I'll say that.
You
with
can't
his-
stop halfway.
Lord, I'll say that with permission of my learned friend and with an apology, because it's not intended to insult. Lord, NGT Pune is a small courtroom. It's like a little slightly bigger bedroom. It's in a government building. My learned friend, all of us were on the same side. He was arguing, Lord, in his own way. Justice Kingaonkar.
In his own volume.
Yes. Justice Kingaonkar was presiding over the bench.
Yes.
So at some stage, he did like this. So my learned friend understood that the honorable judge is unable to cope up with my speed. So he continued the same volume, but reduced the speed. Then I requested my learned friend that the trouble is with the volume, not the speed. And the judge complimented me by saying that, thank you, you prevented Punjab Mail. Sorry, but he's like my brother, my lord. I can take this liberty. My lord, page 204. Lord, this is, my lord, something very, very serious, and your lordships may take this, my lord, into consideration. One constitutional organ prescribing time limits for another constitutional organ Lord, I can, my lord, I have no quarrel and I will never argue, my lord, and I'll pitch my argument that statutory functionaries can be bound by a time limit. The deputy collector deciding to grant or withhold non-agricultural permission. But would it apply to constitutional functionaries which are coordinate constitutional functionaries? My lord, these are the two questions, my lord, which are question number 5 and question number 7. My lord, I have incorporated, my lord, the debate which I have already read. In one line, I may just refresh your lordship's memory. Wherever time limit was stipulated at the time of drafting of the constitution, the time limit was deleted. And in that very provision, wherever time limit was required, time limit is added. So constitutional framers are very conscious of the fact that some functions need a time-bound exercise of power and some functions needs a kind of leeway. And we may not bind the constitutional functionaries with the power. My lord, please come to page 208, and I'm not going to read this, only for your lordship's assistance at page 209. My lord, I have compiled the constitutional provisions where constitution itself stipulates the time limit. I'm not reading it. My lord, this, just my lord, with a view to see that your lordships gets it. My lord, my lord, kindly note one more thing. Tamil Nadu judgment, which mandatorily stipulate time limits for the Honorable President and the Honorable Governor, relies upon the report of Punchi Commission and Sarkaria Commission. It itself says at the end, and obviously so, that these are our recommendations and we recommend suitable constitutional amendments. Meaning thereby, the reliance on the report itself, my lord, in my respectful submission, may not be correct, because Commission does not say that do it by way of a judicial adjudication. It has to be, my lord, logically. I don't have to stretch this point any further. If a commission is appointed by the central government of the day will consider whether to bring it by way of an amendment or not. But very interestingly, my lord, a converse situation has arisen. My lord, in one judgment, which your lordships would find at page 231, where one organ of the state, namely the legislature, provided for the time limit for another organ of the state, namely the judiciary. And matter went before, my lord, 7 judges bench. And your lordships would find the judgment at page 231.
238.
231. Lord, I'm sorry, my lord. One fact, my lord, I missed. Lord, there are judgments which I have cited from page 224 to 231 that even in statutes, court cannot add words, supplement words, or delete words. Lord, the leading judgment.
Causes omissions.
Yes, it is conscious omission. And even if the court were to do it, court can suggest that we recommend or we suggest that the competent legislature may exercise its amending power, either constitutional provision or so. But my lord, one judgment, which is I'm not reading, page 228. 228 is the judgment, my Lord, where my Lord, Justice Narasimha was also, my Lord, on the bench. Suprio versus Union of India. Lord, this is a 5-judge bench, but I found, my Lord, that it is not reportable. It has not been reported anywhere, my Lord. So this was that right of LGBT community, my Lord, my Lord, seeking, where, my Lord, the court said that we cannot read words into the statute. My Lord, this judgment remains unreported. Thereafter, there are 2 judgments which relies upon this judgment, and those 2 judgments, my Lord, including electoral bond, they are reported. But this judgment, my Lord, remains unreported. As a matter of fact, that's all. Otherwise, my Lord, it's a leading landmark judgment, my Lord, laying down several issues of seminal constitutional importance, my Lord, not only for the country, but for the society. I leave it at that. My Lord, page 231.
Yes.
Page 231, my Lord. When, my Lord, legislature, my Lord, provided for timeline for the judiciary. This is where, my Lord, we say the separation of powers, constitutional committee between or amongst 3 or coordinate organs of the state. In P. Ramchandra Rao versus State of Karnataka, Lord, that is 7 judges, has been held that time limits for criminal trials cannot be prescribed. Lord, your lordships would see, sometimes facts may justify time limit, but justification does not confer jurisdiction. We may come across a situation where we feel that it is fully justified, that some time limit should be done. But if there is no jurisdiction, there is no jurisdiction. Justification can never confer jurisdiction. Now, let's see, kindly see, my Lord, what the 7-judge bench is pleased to observe. When one organ fixes time limit for the other, my Lord, incidentally here, it's a converse. Legislature fixing it for the judiciary. Para 225, my Lord, of this judgment I have quoted. During the course of its judgment, also the Constitution bench made certain observations which need to be extracted and reproduced. But then speedy trial or other expressions conveying the said concept are necessarily relative in nature. Kindly pause here for a minute. There are several considerations: lack of staff, lack of my Lord, the burden of cases, several considerations.
Depending on case to case, like.
Case to case, some case may take
Bomb
longer, some case
blast case, there might be 200, 300
witnesses. Lord, that is the justification. Lord, why I am pausing here? Lord, in case of decisions of the nature which governor or the president takes, they are polycentric decisions. They are not ticking the boxes that yes, complied with. There are they may decide, they may choose to call the governor, choose to call the chief minister. They may take some other consultative process to ensure that there is no impasse, etc., etc. And therefore, there may be several reasons for the delay. One may ask, speedy means how speedy? How long a delay is too long? We do not think it possible to lay down any time schedule for conclusion of criminal proceedings. The nature of offense, the number of accused, the number of witnesses, the workload in the particular court, means of communication, and several other circumstances have to be kept in mind. It is neither advisable nor feasible to draw or prescribe an outer time limit for conclusion of all criminal proceedings. It is not necessary to do so for effectuating the right to speedy trial. We are also not satisfied that without such an outer limit, the right becomes illusory. Even apart from Article 21, courts in this country have been cognizant of undue delay in criminal matters, and whenever there were inordinate delay or whether proceedings were pending, where the proceedings were pending for too long and any further proceedings were deemed to be oppressive and unwarranted, They were put an end by making appropriate orders, prescribing periods of limitation at the end of which the trial would be obliged to terminate the proceedings and necessarily acquit or discharge the accused, and further making such directions applicable to all the cases in the present and for future amounts to legislation which in our opinion cannot be done by judicial directives and within the arena of judicial lawmaking power available to the constitutional courts, however liberally we may interpret Article 32, 21, 141 and 142 of the Constitution. The dividing line is fine but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacunae and fill the gaps, but they cannot entrench upon the field of legislation properly meant for legislature. Binding decisions can be issued for enforcing the law, and appropriate directions may issue, including laying down of timelines or chalking out a calendar for proceedings to follow to redeem the injustice done or for taking care of rights violated in a given case or set of cases, depending on facts brought to the notice of the court. Now, my lord, this court says this, my lord, which generally it reserves its own my lord, domain. This is permissible for the judiciary to do. Legislature cannot. But it may not, like the legislature, enact a provision akin to or on the lines of chapter so-and-so of the Code of Criminal Procedure. So legislature cannot. My lord, here also, I think, my lord, the provision was deemed acquittal or something. My lord, it was judgment of the Supreme Court which put time limits on completion of the trials and the. My lord, recently in Allahabad High Court, my lord, judgment also, my lord, where the my lord, that Asian resurfacing judgment that it will have to be decided within 6 months or interim order will be deemed to have been vacated.
So that is reviewed.
Yes.
That is recalled.
That's recalled by a 5-judge bench. 5-judge bench. Lord, here the judgment said judiciary's power is untrammeled, Lord, as per all the judgments, that if it is not decided within 6 months, the interim order is deemed to have been vacated. We are also dealing with, my lord, similar situation where it is deemed assent, etc. My lord, I'll come to that.
Outer limit at all. Real question is, isn't there an outer limit? Can the constitutional interpretation be left to a vacuum? Creation of a vacuum, a long jump,
My lord, there are two answers.
jump by. Of course, we have had that there's nothing like a pocket veto. You just keep it and don't respond. That's not permissible. But though we can't specify a time limit. But at the same time, there must be some way in which the process works out. Can it be a situation where not acting on a bill which is sent to the governor?
No, that is
ਹੈਲੋ ਵਿਧਾਇਕ ਜੀ ਅਸੀਂ ਪੈਸਾ ਵਧਾਓ ਇਨਵੈਸਟਮੈਂਟ ਬੈਂਕ ਤੋਂ ਗੱਲ ਕਰ ਰਹੇ ਹਾਂ ਤੁਸੀਂ ਆਪਣੇ ਪੈਸੇ 10 ਗੁਣਾ ਤੱਕ ਵਧਾ ਸਕਦੇ ਹੋ ਤੁਹਾਨੂੰ ਗਰੁੱਪ ਵਿੱਚ ਸ਼ਾਮਿਲ ਕੀਤਾ ਹੈ ਅਤੇ ਸਬੂਤ ਵੀ ਭੇਜਿਆ ਹੈ
ਤੂੰ ਤਾਂ ਕਮਾਲ ਦਾ ਬੰਦਾ ਹੈ ਮੇਰੇ ਵੀ ਪੈਸੇ ਵਧਾ ਦੇ
ਸਰ ਗਰੁੱਪ ਵਿੱਚ ਜੋ ਕਿਹਾ ਜਾ ਰਿਹਾ ਹੈ ਉਹ ਕਰਦੇ ਰਹੋ
ਅੱਛਾ ਇਹ ਤਾਂ ਬਹੁਤ ਵਧੀਆ ਚਿੰਤਾ ਨਾ ਕਰੋ ਜਿਸ ਨੰਬਰ ਤੇ ਤੁਸੀਂ ਕਾਲ ਕਰ ਰਹੇ ਹੋ ਨਾ ਪੁਲਿਸ 2 ਮਿੰਟ ਵਿੱਚ ਉਹਨੂੰ ਦੇਖ ਕੇ
if that is so, Lord, we are not flooded with cases where, my lord, such situations have arisen. Lord, there are instances where, Lord, 1 or 2 states have come, my lord, with such situations. If that is the problem, and that may be the problem, the remedy lies with the constitutional framers, my lord, with the parliament. The parliament will have to be done. Your lordships have said time and again in several judgments that in view of this, we request the parliament. Your lordships never direct. Your lordships never direct, coordinate constitutional functionary. Even if the notice goes to a constitutional functionary, your lordship's registry's form is also different. You are called upon to remain present is not there. you are requested to put your appearance because that's the constitutional committee. Lord, your lordships have said in large number of cases that the desirability of the parliament to consider this. But the practical answer, my lord, if I were to, my lord, assist your lordships, is the political answer. Suppose a particular governor is, my lord, sitting over the bill, my lord, there are political solutions. And such solutions are taking place. And, my lord, it is not everywhere that state is advised to rush to the Supreme Court. Lord, the chief minister goes and requests the prime minister. Chief minister goes and meets the president. There are delegations which go that this is the bill which is pending. Please talk to the governor. Let him take decision one way or the other. Telephonically, they are sorted out. There is a joint meeting with prime minister, chief minister, and the governor, or the president, chief minister, and the governor. And such impasse is not solved. So that would not confer jurisdiction to lay down a guideline by a judgment. That is the question. That in absence of a constitutionally provided guideline, time limit, can it be read even if there is a justification? And my lord, genuinely, my lord, I'm urging your lordships to consider such issues are arising in every state since last many decades. I'm not talking of this government or that government, but the statesmanship, the political maturity, the political statesmanship, they are at play. They meet the constitutional functionaries at the center. They discuss, debate, because all bills are not contentious bills. They are kept, my lord, for one reason or the other. There is some impasse, some lack of communication. Some clarification might be required, which might be wanting. Then, my lord, they come together and a political solution is found that, all right, if you don't want to do it, refer it to the president will examine. Lord, these are the solutions of the problem. Lord, I'm therefore, my lord, at the cost of making a little unpleasant argument, my lord, saying that every problem in this country may not have solutions, my lord, here. There are problems, my lord, in the country where you must find solutions within the system. This is what your lordships have said in this judgment, that there is a question of delay. Article 21 is affected. People are languishing in jail. But solution will have to be found from within the system. And your lordships are doing a lot from within the system for streamlining, for ensuring that timely trials take place with assistance of the legislature. Now we have a lot of the legislative provisions that even summons can be served through electronic mode. Even a WhatsApp message is a good service of summons. How responsibilities are fixed for the officers to bring in witnesses, etc. But this is a collaborative exercise. Lord, suppose, my lord, there is a bill passed by the parliament. Kindly, my lord, suppose there is a bill passed by the parliament that people of the country are approaching us, that my trial is pending since 30 years, my son is in jail, and it is not being taken up. I'm posing a question to myself, my lord, can the executive, maybe the president of India, say that, no, I understand there is a problem, and therefore your trial is treated to have been terminated. You are deemed to have been acquitted. You have already undergone 30 years. It cannot be done. Justification can never confer jurisdiction. And this separation of power, what I'm saying without mincing words, must be a two-way street. Lord, I'll just show your lordships Allahabad judgment, where there was again a judicial verdict, where within 6 weeks, if it is not done, 6 months, then it is vacated. Then, my lord, this court, my lord, speaking through 5 judges bench, set aside that no time limit can be prescribed. Now, please come to another judgment, which is again a landmark judgment, my lord.
Mr. Solicitor, that against the inaction of the governor in a particular given case. It can vary from state to state, it can vary from action to action, or inaction to inaction.
My apologies.
In a particular case of inaction, if the aggrieved state or its functionaries, if they approach the court, the power of judicial review according to is completely barred.
Look, right now, I am on the point, I'm not on justiciability or judicial review. I am on the point that by a judgment, the court cannot fix time limit. That you do it within 3 months.
All right, we will expand this argument and then we'll also enlighten then what kind of the
Remedy is available to
remedy
other
the
person.
courts would.
Therefore, my lord, I answered,
If there is a wrong, then there has to be a remedy.
Ubi just Ibi remedy, my lord, I understand. But there are, my lord, problems which all problems in the country may not be this forum to be the only solution. There are solutions, my lord, within the system and people are finding out those
No,
solutions.
no, as the custodians of the constitution. This court is a custodian of the constitution.
My lord, each organ is, my lord. Each organ is in their own respective fields, my lord.
Suppose if a constitutional functionary, which is entrusted with certain function, refuses to discharge those functions without any valid reasons, whether the courts, the hands of the constitutional court would be tied and say that, no, we are powerless.
It's not, my lord, an
Power of
argument of,
interpretation only the Supreme Court has of the
My lord,
Constitution.
my lord, that is the feeling, my lord, that all problems.
Interpretation of the Constitution.
Interpretation, yes. Yes, yes, sir.
Court has.
Interpretation, yes, my lord, but not legislation.
No,
Now
not
there is a problem, you do it in 3 months. Kindly see, my lord, the way, my lord,
For that, cannot we go to the constitutional debates? Find out what was the intention of the Constituent Assembly behind enacting such provisions. Can't we do that?
no, no, your lordships can consider, my lord, whichever way, my lord. My argument is this, my lord, that time limit cannot be stipulated.
If the power of interpretation of the constitution, if the power of interpretation of the constitution rests in the Supreme Court, then rules of interpretation of law are to be tried by the court.
My lord, then, my lord, my answer is one answer. Justiciability is something else. Adding words or amending the constitution itself, your lordships have said even statute cannot be amended by judgment, is something else. Generally, and this is my answer, my lord,
We have to go on the first principle, literal interpretation.
basically, my lord, what a tap on the back jurisdiction, my lord, as we understand. You can always say that just look into it. You can call the law officer, just look into it and see that it is done, and it is generally done, my lord. But please see, my lord, the directions. My lord, I would respectfully urge your lordships to see that.
We agree. That if extreme view is taken, is no justification to argue that you can't therefore take any view at all. We are not at the two extremes of prescribing time limits now here within 1 week or so. Or on the alternative, don't have a power at all to do it.
My
There
lord,
must
I'm
be a
coming,
way by which you make the constitution work,
my lord,
process work.
flexibility has to be there. The system must work smoothly.
No, there is no doubt that you must have free play in the joints.
My lord, kindly see the
But,
direction for my satisfaction.
Yes, that is,
From page 12569, volume 31, volume 31, Roman 531.
they begin at 12569.
No, no, the relevant part, the directions, my lord, where in our submission, my lord, this amounts to amending the para, my lord, is Roman 14 of the conclusions.
Yes.
These are, I'm reading the conclusions.
125692,
12569. Your lordship said, my lord, it starts with timelines. My lord, kindly come to 12568 first. What is this, my lord? Your lordships would, and with profound respect, my lord, every judgment deserves the respect, my lord, and maybe there may be a justification for doing this, but my argument is justification do not confer jurisdiction. My lord, 14, keeping in mind the constitutional significance. Your lordship gets, my lord?
Yes.
My Lord Justice Narasimha gets. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Failure to comply with these timelines would make the inaction.
बादल, बिजली, बरखा या फिर वो कोई मंदी का झोंका, इन्हें किसी
There are three options in the main body of the article.
in the main provision.
Yes. Each have a finality and a consequence attached to them. And each have to be preceded by an affirmative act of a declaration.
And
Each is followed by, each is preceded by
Declaration.
a affirmative act of a declaration. The words used are shall declare. And then the words used are either that he assents to the bill,
each is preceded by an act of declaration.
declaration, which says that either that he assents to the bill or that he,
Therefore, since we begin, now it has to be preceded by a declaration.
yes,
So if the honorable governor, for time immemorial, doesn't even declare that he is withholding the sanction, and even in such a case, his court would be powerless.
but that is why I respectfully submitted when I opened that the issue of justiciability and the supposed inaction of some governor, I'll deal with later. Let me first deal with the construction of Article 200 and then what would be the options available to your lordships in exercise of your lordship's jurisdiction if a situation does emerge where there is a governor who's been sitting on a bill for years, not acting on it. We've had the benefit of your lordship's views and I'll attempt to address that question later. But for the moment, my lords, let me first address 200 as it stands, the reading of 200. Now, my lords, each of these actions, as I said, declarations has a consequential effect. In the case of an assent, it becomes an act, the bill. In the case of withholding assent, constitution benches have said that the bill falls.
False.
And in the case,
Unless,
I'll come to that. I'll come to that. my lords. And the third part is it goes to the president. It is reserved and goes for the opinion of the president. True. The fourth option, my lords, is actually in the nature of what fell from my lords, more in the nature of a preliminary option. That is, as part of the consultative process, because as your lordships will recollect, Article 396, where the subchapter begins, the heading is legislative procedure. And your lordships have said that even the governor's decision is this, is part of the legislative process.
is a part of the legislature.
Legislature and legislative process. The heading is legislative procedure. 196 is preceded by saying legislative procedure, and I'll show the judgment, my lords. I'll show the judgment on the point. The purpose of that is, my lords, under the proviso is that there is a consultative process also envisaged, where the governor may send recommendations, may want the House to reconsider. Could be a case where he's willing to assent but feels certain things require a bit of tweaking. may think that there are constitutional concerns or issues of repugnancy or many other issues, and I need to send it to the president. But before sending it to the president, let me at least first send it to the House, expressing what my views are, and after that it comes, I can always send it back. What he can't do after returning it is that he cannot thereafter himself withhold assent. Only word used there is shall not withhold assent. Shall assent or reserve for the president are not mentioned there. That's the only thing, the only option which goes away after you return the bill. But this returning the bill, my lords, A is presentation to him of the bill for assent. The words used in the proviso are not on withholding of assent, he must return it. The words used are presentation to him of the bill for assent. Now, if return of a bill was to be treated as an adjunct, as has been sought, to withholding of assent, it could have easily said in the main body, withhold assent and return. The words used in the proviso are as soon as possible after presentation to him of the bill for assent. And I'll tell you, Lordships, why the words used as soon as possible here are. The reason as soon as possible here are that the framers of the Constitution imbibed an expediency to it, given that this is really the preliminary option. Unless to the second option and does not add it to any other option is this, my lords, that if the Honorable Governor gives his assent, naturally the bill becomes the act, it doesn't fall through. If he reserves it and sends it to the president, it still is a bill which goes to the president for his consideration. It is only in the case of where the withholding of the bill takes place by a declaration that it falls through. So the words used are in the judgment are that this bill will fall through, unless of course it is sent to the, that is the purpose of the bill. That unless in a constitution when judgment can't be picked up to mean that the proviso to Article 200 says that the return of the bill is an adjunct to withholding of assets. That's why, my lords, I respectfully started by saying that the first words in Article 200 are a positive affirmative act of shall declare. And shall declare with those three options. Shall declare withholding assent, it falls. Shall declare giving his assent, it becomes an act. Shall declare it is reserved for the president, it goes to the president. But there is a preliminary option given there, which of course the rider, that if you exercise that option, then one of those three options are taken away from you, which is the second option of withholding assent. That goes, there's no doubt about it, no quibbling with that.
That goes, so either he has an option, either to give assent or to send it to the president. That would be your summary.
Grateful, my lords, because I'm very grateful to Honorable the Chief Justice that the words used then in the proviso are the governor shall not withhold assent therefrom. It could have said shall assent. Didn't say so. Shall not withhold is the second option.
The option of withholding goes.
Yes.
But still, according to two options remain.
Yes.
Either to give assent or send it to the president.
That's right. Because, my lords, as I respectfully submitted, the philosophy behind it is that as being part of the legislative procedure or process, there is also an inbuilt consultative mechanism. And I'll come to some of these memorandums, my lords, when I come to the issue of timeline, and I'll show to your lordships that even Dr. Ambedkar, while dealing with the duties of the governor, said he must advise. It is his duty to advise. It is his duty to interact with the ministries concerned on proposed legislations. I'll come to that article.
Friend, philosopher and guide.
Very grateful. So under Article 167 of the Constitution, my lords, a chief minister is duty bound to ensure that all ministries send the requisite information and material to the governor on any proposed legislation. And I'll build that argument as I go along. The purpose being that he is not sitting there as a rubber stamp. That is why judgments of this court have held that there is explicit discretion vested and there is implicit discretion vested in the governor. Word discretion may not have been mentioned in Article 200, but your lordships in your lordships various constitution benches have said he's not bound by the aid and advice, irrespective of the aid and advice. The discretion is there to act on his own. It is part of that consultative process that he in his wisdom, maybe with recommendations, maybe without recommendations, maybe with suggestions, maybe without suggestions, sends a bill back as a fourth option to the assembly to debate on it. He no doubt in the process then gives up his second option of withholding. That's the framers thought is the best option. That's in their wisdom, they've decided. We are bound by it. But to say that the proviso means that the moment you withhold assent, you are duty bound to send it to the Legislative Assembly is wrong. Because, my lords, neither does the Constitution provide for it, nor does the textual context provide for it, and there is no basis for it to come to this conclusion at all. And that is why I started by saying, my lords, that the word shall declare, and all constitution benches, even for the main part, have said three options. And the words used are either. Either are all three options mentioned there. There is no basis to say that because it uses the word as soon as possible, this is an adjunct to withholding and thus should be sent back. There is no constitutional basis for this at all. My lords, my next argument for your lordship's kind consideration under the same head is that if your lordships were to also see the historical significance and evolution of Article 200, your lordships would see that under the Government of India Act 1919.
हेलो
नमस्कार विधायक जी, हम पैसा बढ़ाओ इन्वेस्टमेंट बैंक से बात कर रहे हैं। हम आपके पैसे
Reconsideration to the council was an option. Withholding of assent was also an option. It wasn't that it was an adjunct. It was an option. And the words my lords used in the article were, instead of declaring that he assents to or withholds his assent from the bill, return the bill to the council for consideration, for reconsideration.
So I think we need not go to the pre-independence statutes because 200 has been now enacted after due deliberations in the Constituent Assembly, and therefore we could be guided by the deliberations in the Constituent Assembly rather than going to the.
I'm
70 years have passed.
absolutely. No, my lords, I'm very grateful. The only reason I said was
We'll
that,
follow the learned solicitor in that rather than following the British laws. Now we
yes,
follow the.
yes, my lords, except
What has been enacted by the
for saying that this proviso always existed as an option. That's the only limited point I'm making. I'm not saying that your lordship needs to go to the Government of India Act for interpretation, but to have it as an option is not an unknown thing. It is historically as an independent option always existed. And in fact, my lords, only to this limited extent, the government, it's really a discretion argument. The Government of India Act 1935 had the word discretion in it. Article 200 did not have the word discretion in it. And despite that, constitution benches of this court said that irrespective of the aid and advice of the Council of Ministers, independent discretion is vested in the governor while exercising power under Article 200. The purpose I'm saying so, my lord, when I marry it into the time argument, the timeline argument is, the Constitution envisages a back and forth between the state and the center, between the ministry and the governor, information being given, deliberation, application of mind, formation of opinion, sending back to the assembly for reconsideration. It's a whole process which is provided for. It's not as if a bill comes, immediately declare one way or the other, and that's the end of it. That's not what it envisages. Manoj, my second argument, my lords.
So the word is not, discretion is not mentioned,
Yes.
but still options are given. So when more than one options are given, it is presumed that there is a discretion.
Yes. Yes.
And Article 163 discussions would also show
Absolutely.
that they said that Dr. Ambedkar as well as T.T. Krishnamachari, they said that as and when we progress towards the other articles, the provision in 163 is to safeguard that wherever discretion is provided in the foregoing articles, same would be preserved.
Because
It can't be a generalistic.
I can't put it better, my lords, than 163(1) and 163(2). Both, and then the discussion, it says that there is explicit discretion, there is implicit discretion. And clearly this is a case which is now interpreted no longer res integra, that discretion does exist, and for good reason it exists. My lords, one more question, my lords, and Justice Surikant in particular put to me when I briefly intervened on the last date, was that if one option is exercised, would it mean, when we are answering a constitutional reference, would it render the other options ocious? My lords, that's a question. Please correct me if I'm wrong, my lords. That's a question which fell from my lords. My lords, the answer to that would be, my respectful submission would be, the very fact that the article gives 3 or 4 options obviously gives you a choice to choose one. Merely because you choose one does not make the others ocious. It's a matter of choice. So if, for instance, an assent is given, naturally then assent can't be withheld. Then it naturally can't be sent to the president. If it is sent to the president, naturally it can't be withheld or assent be given. So the natural consequence of opting for one of the 4 options is that the others have not been opted for. But this is not an ocious situation where an interpretation to a clause or a part of the constitution renders another article or a clause, as would happen, say, any other case, ocious. It's not an ocious situation. That's all that I'm saying, my lords. It's an exercise of discretion by the governor on one of the options provided to him.
The other facet of this very argument was that whether the power of the governor to withhold also include the power to withhold temporarily.
My lords, yes.
The question is not of taking away the power, question of reading the power of the governor, whether the power to withhold also include the power to withhold temporarily.
My lords, to answer that and taking cue from what fell from Justice Narasimha yesterday, that is why I started by saying that also the proviso in a way becomes out of the 4, a kind of the first preliminary option of before taking a all 3 others have a categorical finality to it. Assent, act, withhold, false, false, reserved for president goes to the president. So before that, as part of the legislative process, as part of the consultative process, send it. So to that extent, my lords, that's what my answer is.
According to it, it's possible for the governor, for the honorable governor, to first exercise the option under proviso. And then after the bill comes, then exercise either of those 3 options.
Either of the 2.
Either of the 2, because withholding goes.
That he knows. The moment he sends it back, he is giving, because the constitution mandates that. Even if he wanted, he can't do that. So that goes. But the other 2 options remain. But he thinks in his wisdom. And I said, my lord, there may be cases, leave aside withholding. There may be cases where the governor actually feels this is a bill which is fit for an assent. But I feel something needs to be tweaked or changed. Let me send it back once. Or he may think, yes, there are serious constitutional concerns of repugnancy or otherwise. I need it to be sent to the president. But before it is sent to the president, let me first suggest to the House.
Let them have an opportunity to.
Yes, let them give it. So that is why I respectfully submitted this whole argument that a proviso is a necessary adjunct to option 2 is wrong. It is contrary to the bare reading of the provision itself. And there is a reason why it's been put the way it's been put. An option as a fourth option is nothing new which is being done. It's not an argument being made by us for the first time. It has a historical basis. That's the only limited point I said this one.
One of you will also enlighten us that what is the meaning of shall declare?
What, my lords?
What is the import and meaning of the expression shall declare?
Shall declare. Yes, my lord.
Is it a kind of formal declaration, informal declaration, implied
Yes.
declaration, express declaration?
Yes, my lords. Yes, my lords. Implied or expressed, my lords. I'll have a look at it. Very grateful, my lord.